All right. Good morning. Happy Friday. Thank you for joining us this morning. Know that you probably got a busy Friday ahead of you, so we're going to go ahead and get started. My name is Scott Williams, and I'm a partner at Burr's Labor and Employment Practice Group. With me this morning is Gabrielle Jeffries, who is an associate in our Labor and Employment Practice Group. And both Gabrielle and I work out of our firm's Birmingham, Alabama office. In our practice, Gabrielle and I represent management and employers with respect to all labor and employment matters, including OSHA compliance and whistleblower cases. Just looking at the attendees, I recognize a lot of you, and I'm sure everyone in attendance this morning has some responsibility for workplace safety, whether you're an HR role or EHS role or some hybrid role wearing multiple hats. As you all know, the Occupational Safety and Health Act is the federal law that requires employers like yourselves to provide a workplace free from recognized hazards to safety and health. OSHA has two main functions. One, setting uniform health and safety standards, and two, conducting inspections to ensure employers are complying with those standards. For today's purposes, we're going to focus on OSHA's second main function, which is conducting the on-site walk-around inspections, particularly OSHA's new final rule on walk-around inspections. We are going to have time for questions at the end, so please use the Q&A box at the bottom of your screen to submit questions. If Gabrielle and I see them as we go along, we'll try to answer them as we go along, but we'll certainly try to get to as many questions as we can towards the end of the presentation. So let's talk about OSHA's new walk-around rule. On April 1st, OSHA published a final rule that allows employees to designate a third-party representative to accompany an OSHA compliance officer during the walk-around inspection process. This is regardless of whether the representative is an actual employee of the company. The rule did become effective on May 31st, and we want to take a look at some of the specific changes the new rule makes.
So this rule is not completely new. There was a prior rule in place that authorized both employers and employees to have a representative accompany the OSHA inspector during the inspection of the workplace. So this is a change to an existing rule. The prior rule, it limited the authorized representative of the employee at least to individuals employed by the employer. So the employee's representative under the prior rule had to be someone who also worked for the company. Now, there was still a provision in there about third parties, but third parties were only allowed when the inspector had established good cause why accompaniment by a third party is reasonably necessary to conducting effective inspection. And in the prior rule, it didn't have much explanation of good cause or what reasonably necessary means, but it did specifically list the types, or at least two examples of third parties that were contemplated by the rule. And those were industrial hygienists and safety engineers. So people with formal credentials.
So under the new rule, when the designated employee representative is not an employee of the company, they may still accompany the OSHA inspector if, in the judgment of the OSHA inspector, good cause has been shown why the third party is reasonably necessary to conduct an effective and thorough inspection. So what does good cause mean? Well, according to the final rule, the good cause determination should be based on the third party's relevant knowledge, skills, or experience with hazards or conditions in the workplace or similar workplaces, as well as language or communication skills.
And so we've talked about what the prior rule allowed, and then you've seen the text of the new rule. So we wanted to point out three key differences between the two here. First, the one that we're probably going to focus most on is that the new rule allows for a wide variety of third-party employee representatives. So that requirement that I talked about with the prior rule, that the employee representative be an employee of the employer, is no longer required. That limitation is not there. Additionally, that reference to, the industrial hygienist or a safety engineer is removed. So what that means is it no longer has to be another employee of the company. And the third party language has been expanded significantly, meaning it doesn't have to just be a person with these formal credentials anymore. And the language shows that third party representative must be reasonably necessary. So the new rule did define a little bit what reasonably necessary means. So that's our next biggest difference. And as Scott said, that can be because of an individual's relevant knowledge, skills, or experience with hazards or conditions in the workplace, or similar workplaces, or even language or communication skills. So this may be technical knowledge, it could be practical experience, or that third one there that, there was lots of mention of in the proposed rule and then the final rule is facilitating communication. So OSHA stated with regard to this rule that, third parties can increase worker involvement in the inspection by facilitating communication between workers and OSHA. So that really broadens who this can be. That can mean something as simple as communication skills, language skills. So it could be a translator, but generally facilitating communication can be interpreted very broadly to allow, going back to that first point, a wide variety of third party who can potentially be the authorized employee representative to accompany the inspector on the inspection.
Yeah, so as Gabriell said, no longer is the third party representative limited to an industrial hygienist or safety engineer. But the final rule does list some examples of possible third party representatives, including, but not limited to, a union representative, a worker advocacy group, and attorneys on behalf of a group or organization. And in terms of a union representative, we're not talking about limiting that representative to workplaces that are already unionized. This includes union representatives being designated by employees in non-unionized workplaces. I don't think this is a hot take by any means, but in our opinion, this rule is not an effort to improve the OSHA inspection process. Instead, it is designed to provide labor unions an advantage in their organizing efforts by granting non-employee union reps access to non-unionized facilities and giving them direct interaction with non-union employees.
So one of the biggest questions that came up when this rule was proposed is, what is the role of the third party employee representative for these inspections? And so the text of the rule just says that they may accompany the inspector on the inspection. So the question naturally was, what does that mean? Well, this hasn't really changed much. They still can do what any previous representative of the employee or the employer could do. And those are: one, accompany the inspector during the walk-around inspection. So physically be there. When they go out to view the area, walk around with them. Attend the opening and closing conferences. Ask clarifying questions to ensure understanding of a specific item or topic of discussion. So there was some comments addressing initially whether this was just merely an observation role. OSHA has clarified that it is not. They still have the ability to ask questions, ensure understanding, attend all of these events. And then finally, also attend employee interviews as long as the employee requests their presence. So if the employee is okay with it, the authorized employee representative, even if they're a third party, can sit in on those interviews as well.
So as you would expect, the business community, including non-unionized workplaces, are not very excited about the change in this rule. And there have been legal challenges. In fact, a coalition of business groups, including the U.S. Chamber of Commerce and the National Association of Manufacturers, filed a lawsuit in a Texas federal court in May, claiming that OSHA exceeded its authority by implementing the final rule and claiming that the final rule violates an employer's constitutional right against unreasonable searches, the Fourth Amendment, and the constitutional right to due process, the Fifth Amendment. However, the federal court did not enjoin or otherwise block the final rule from going into effect on May 31st. So while there are legal challenges pending, this is the law of the land in terms of every workplace subject to OSHA inspections. And even if you're in a state with a state plan, Tennessee, South Carolina, North Carolina, Kentucky, as a OSHA approved state plan, your state plan is going to have to adopt this identical regulation or at least something as effective going forward. So it does apply to state plans as well.
So the next part of our presentation, we want to go over some employer considerations. So we've talked about this rule, what the prior rule looked like, the differences with the new rule, what that means, who these third-party representatives could be, and then some legal challenges to the rule. But we know that probably what most of you are concerned about is what this actually means for you. What do you do if this happens? If the OSHA inspector shows up and there is an employee representative that is attempting to accompany them on the inspection? Well, we have put together some potential options for an employer approach. So if you'll remember, it is at the judgment of the inspector whether good cause has been shown why accompaniment by the third party is reasonably necessary to conduct an effective and thorough inspection of the workplace. So our first step is simply to ask the inspector to demonstrate good cause. So under the new rule, like under the old rule, it is the inspector's burden to show good cause as to why accompaniment by the third party is reasonably necessary. So going along with that, the second step is question why the third party is reasonably necessary. So ask for an explanation of specifically what it is that makes that person necessary, what relevant knowledge, skills, or experience that they have, whether that's with hazards or conditions in the workplace, similar workplaces, if it's a language or communication skill issue. Just make sure that you ask them to provide a thorough explanation of why that third party is reasonably necessary, because it is there must be good cause showing that. And ask follow-up questions. Don't just take a simple short answer about it. Ask follow-up questions. Make sure you get to the root of why they feel that this individual is reasonably necessary. And then with both of those steps, this is a very important one. You want to document the questions that you asked and the responses for the record. So take very clear notes of why the inspector says that this person is reasonably necessary. You want to document what they're saying, why they're saying they have good cause for this third party joining in on the inspection, because this may be important later on. So we want to preserve this for the record.
Yeah, personally, I believe it's going to be very hard for a compliance officer to show good cause in most situations. There may be a situation where you have a specific hazard in your workplace where someone with specialized degree or knowledge might be reasonably necessary to conduct an effective and thorough inspection. But in most instances, it's going to be very hard to show good cause. But if for whatever reason you do believe good cause exists and you decide to allow access to the third party, please make sure to limit the third party's role in the inspection to what Gabriell has mentioned, only the walk-around portion of the inspection and only attendance at the opening and closing conferences. In the alternative, if you believe good cause does not exist or that the final rule is a violation of your company's rights, you may want to consider refusing entry to the third party. Now, let me be clear. What I mean by that is you make clear that you're not refusing access to the OSHA inspector, only the third party. At that point, the OSHA inspector will have to decide whether or not he or she is going to go through with the inspection or insist that the third party be allowed to accompany him or her during the inspection. If for whatever reason the OSHA inspector takes a stance that the third party must be allowed to accompany him or her, then you could also refuse entry to OSHA. Of course, this will ultimately put the burden on OSHA to get a warrant for the on-site inspection. And if that warrant then requires that the employer also permit access to the third-party rep, then you could consider filing a motion to quash the warrant and take the issue to court. It all goes back to establishing good cause at the forefront of this happening to you in your workplace. As Gabrielle said, we need to ask the question, we need to document the response, and have that on record if we end up in court and have to file a motion to quash any warrant, in federal court.
So our final issue here is we want to talk about a few additional considerations with this rule. So one of the ones here is labor relations. So what we mean by that is we've talked about the various people that this third-party representative could be. One of those that Scott mentioned earlier is, a union official or representative. If an inspector shows up and the employees are seeking an authorized representative that is a union official, that's a clear indication that you have activity at your facility. You may not have known it before, but you are aware of it now. Another thing that shows is that safety is likely to be a focal point of any organizing efforts. You may have an influx of OSHA complaints or issues, and this can show that you can expect safety to be a key issue, and it should also be a strong focus for you as an employer.
Yeah, another additional consideration that we recommend is that before OSHA shows up at your work site with a union representative or any other third-party representative, consider establishing or recommitting to a safety committee, an employee safety committee. There's a very strong argument based on OSHA's own FOM, Field Operations Manual, that an employee designated safety committee would hold that employee representative role in a walk-around inspection. A third-party representative should not displace the existing employee representatives chosen by the non-management employees and the employee safety committee.
Another consideration that we want you to keep in mind is confidentiality. So OSHA has anticipated that these third-party representatives will have to comply with the employer's established rules and policies. So one thing you want to do is make sure that you are ensuring confidentiality for this individual who is a third party who is being allowed into your workplace. So one way that you may be able to do that is with having them sign an NDA or confidentiality agreement. OSHA has indicated that as long as this requirement is similar to what you as an employer would require for all other visitors and does not interfere with the third party's right to accompany the inspector during the inspection, that this may be permissible. So you may want to have these agreements in place and have the third party sign them to ensure confidentiality. But a couple of things that OSHA has noted is that this can't, these types of agreements can't restrict the individual's ability to discuss the inspection with OSHA or employees affected by the inspection, or restrict their participation in any future enforcement efforts.
And finally, you continue to have the right to protect your trade secrets. During an inspection of an area containing trade secrets, OSHA's regulations still permit an employer to limit employee representation to an employee who works in the area or an employee authorized by the employer to enter that area. Because of this, we recommend that you as an employer reevaluate your designated trade secret areas and treat them accordingly. So for example, if you're currently giving public tours to the local high schools of designated trade secret areas, you're not going to be able to make this argument if OSHA shows up with a third-party representative that you only allow access to certain employees to those trade secret areas. But in summary, you should understand your rights if OSHA arrives at your work site and have a plan before you are asked to allow a non-employee to accompany an inspector at your work site. I think with the time we have left, we're going to check these Q&As and we're happy to take any questions you may have. All right, well, I don't see any questions. But if and we're not aware to date of any client who has been subject to this new rule where OSHA either shows up with a third-party representative or later an employee comes forward and designates a non-employee as a third-party representative. So we have not seen this rule in practice as of yet. Certainly, if you think of any questions later, you can reach out to Gabrielle or I, and we'll be happy to help you in any way that we can. All right. Well, thank you so much again for your attendance and have a great weekend.
Thanks, everyone.